So there's a story here. Unregistered designs in this country have been a little bit complicated for a while because there are different types of them. The Copyright Designs and Patents Act in 1988 set up the UK unregistered design, and that protects the shape of products, or the shape and configuration of products or parts of products, as the law says. And then so we had this UK unregistered design right throughout the whole of the 90s. Early 2000s, the EU design regulation set up, among other things, EU unregistered designs, and that has a different definition. So similar sort of idea, but the bottom line is that there are things that the old UK unregistered design right probably protects, EU unregistered design right probably doesn't protect, and there are also things that the EU unregistered design right probably protects that the UK design right doesn't protect. So we had these two systems running in parallel. So since the early 2000s, a UK design owner has had potentially UK unregistered designs and EU unregistered designs. Slightly different rules and different tests associated with them, but you've got both, which is good. Now, what happened next, as everybody knows, of course, is the UK left the European Union, and that meant that the EU design regulation is no longer has direct effect in the UK. So an EU unregistered design as such is no longer enforced in the UK because it's enforced in the European Union. But obviously, as part of the preparations for Brexit, the government recognised that the EU design was and had been valuable over and above the sort of indigenous UK right, and so they decided to copy it. The EU design regulation has essentially been cut and pasted into UK law, and so what we now have is the UK unregistered design, which exists with some perhaps minor changes, as it did since 1988, and we have what's called a supplementary UK unregistered design, which is the carbon copy of what the EU unregistered design did when we used to be members of the European Union. So we've got these two rights that exist in parallel, but there's a catch, and the catch arises out of the fact that the EU law was never particularly clear about what you had to do to get EU unregistered designs. In particular, there is uncertainty as to whether to get an EU design you have to first disclose the design in the EU, or whether it can be somewhere else in the world as long as the people in the EU would find out about it. The law is unclear in that respect. There were actually questions referred to the European Court of Justice by the UK courts just before we left. Those questions unfortunately will never be answered, and that's not the fault of Brexit actually, it's because the parties to the dispute settled. So the European Court of Justice, which was going to have to answer this question, do you have to disclose the design first within the EU, physically within the EU, in order to get your EU design right, isn't now going to answer that, at least not in that case. It will have to wait for another court in a different EU country to have a case and refer those questions if they want to do that. The best that you can do is probably to make sure that you try and disclose everywhere at once, so that your disclosure in the EU doesn't prevent you from getting UK unregistered or UK unregistered supplementary designs, and your disclosure in the UK doesn't prevent you from getting EU unregistered designs, and indeed your disclosure anywhere else in the world, be it the USA or Australia or wherever it is, doesn't stop you getting both. So disclosing everywhere at once, to the extent that that's possible, is a good idea,